Please welcome him.
Thanks, Shannon. Good morning, everybody. It's good to see you. This is a really good time of year for a legal update for a couple of reasons. First of all, on September 30th was the last day for the governor to veto any pending legislation, so we know by now what new laws we're going to have on the books for next year that affect real estate. And also, we're anxiously awaiting the California Supreme Court's decision in a case called Horaki versus Coldwell Banker, which I'll talk about a little bit later. That's probably the most significant case involving real estate brokers in the last several years. So even with all that important stuff going on, though, for those of you who were at the Property Management Summit last month and heard me talk for 3 hours, you understand why they told me, Jim, we'd like to have you back, but you can't talk for 3 hours this time. We'll give you 20 minutes. So this is going to be kind of a short synopsis of some of the more significant things that are going on legally these days. There's a new law on the books, and one of the things you'll notice as we go through, I got about probably 12 or 15 new statutes to talk about. They have all sorts of different effective dates. Usually this time of year we're looking at laws that are going to be effective on January 1. Many of these are already effective because they were enacted on an emergency basis, and some of them, as in this case with Assembly Bill 1650, it's not effective until January of 1918. And what this does, it kind of clarifies and broadens the requirements in connection with your advertising. As you guys know, under current law, you must disclose your license number on first point of contact solicitation materials. Typically business cards, correspondence, that type of thing. Under the new law, which goes into effect in another 14 and a half months, you're going to have to disclose your name and license number, not just the license number, on most materials that you hand out, not just first point of contact things. So it's going to extend to advertising and for sale signs. It also clarifies a little bit what's going to be required and what the exceptions are. Most of the exceptions we have now are going to be gone. You're going to have your name and license number on for sale signs, for example, with a couple of exceptions. If your responsible broker's identity is shown or where there's no licensee identification at all, for example, if you just have a sign that says for sale, you don't have to have it on that. And then the new law talks about broker identity. Instead of broker license number for your responsible broker, you're going to need to have the broker's identity. And that's defined as the name that the responsible broker uses with the Bureau of Real Estate and in its own conduct of business. So we got that coming up. Kind of related to that, there's been a slight change in the team name advertising rules. This Senate Bill 710 was sponsored by the California Association of Realtors. Previous law required that all team name and agent-owned DBA advertising include both the responsible broker's name and license number. The new law, kind of consistent with the law we just talked about a minute ago, requires only the responsible broker's name. Display of his or her broker's license number is optional now. There's a new law on the books, effective again in January of 2018, sponsored by the California Association of Realtors, that addresses the issue of broker-associate relationships. As all of you know, a broker can be associated with a brokerage company now, but the relationship really isn't disclosed on BRE website, its records, and there isn't any requirement that the broker with whom the broker associate is associated notify the Bureau of the Association. So under the new law, whenever a broker becomes associated with a brokerage firm, the Bureau has to be notified. And whenever a broker-associate relationship ceases for any reason, the Bureau has to be notified. And the CalBRE website now is going to show the actual relationship between brokers and the company they're working with. It's kind of interesting, the new law doesn't use the word broker-associate, which we're all familiar with. It refers to quote-unquote associate licensees or to brokers acting as a salesperson. So keep in mind, January of 2018, that's going to be in effect. Right now, if you get caught in a problem with the Bureau of Real Estate and there's any discipline whatsoever against your license, even if it's just a short suspension that's bought out and stayed and never even effective, that stays on your public record forever. I mean, 25 years after it happens, you're still going to go to the Bureau website and see all the stuff that happened in connection with the discipline against your license. There's, effective January 2018, that's going to change slightly. It's going to be possible then for somebody who has discipline against their license on their record to file a written petition asking that that be taken off the public records. And before everybody gets real giddy with excitement over this possibility, if you have a situation where you're looking forward to this happening, there are a lot of requirements, and it seems to me it's going to be really difficult to satisfy the Bureau's requirements to get that discipline removed. First of all, 10 years will have had to have passed before, after the discipline's imposed, before you can even make the written request. Then you must provide evidence to the Bureau of rehabilitation. Basically, you're going to have to prove to them that not publishing the discipline that affected your license will not pose a risk to the public. And then, as with just about everything involving the Cal BRE these days, you're going to have to pay a specified fee, and we don't know what that is yet. There'll probably be regulations specifying that before this goes into effect. But then if you satisfy all those criteria, the Bureau can consider and grant on a case-by-case basis removing the published discipline from your online record. The fact that you were disciplined is going to still stay in their files, and it won't be published any longer, but it'll be important if there's any subsequent issues or problems that come up. AB 685 is effective January of this coming year. It has it's kind of an omnibus statute that has a few things in it. First of all, there's been a lot of furor in recent years about the outdated technology in the real estate license law. Everything refers still to salesmen and salesmen, and that's going to change now. They're going to get rid of all the references to the gender problem references to salesmen are going to now be to salesperson and salespersons. So they finally come into the 21st century on that. There's a couple of other little things that are part of this new law, and they're kind of minor changes, but basically right now under current law, the commissioner can issue a citation to somebody if they find that they're practicing real estate without a license. That law is going to be extended to say that if they've caught somebody doing that and there's been a citation and the terms haven't been complied with, they can refuse to give that person a license if the person applies for a license in the future. Similarly, if any licensee has a fine outstanding, for example, under the new cite and fine program that the Bureau has, if that hasn't been paid or the conditions haven't been met and somebody applies for a license, the Bureau can refuse to grant it on that basis. That would seemingly go, I can see where that might happen, where if somebody were cited and they move out of state and they no longer have their license in California and they come back at some later date, years down the road, and they apply again, they can catch up with you then and they can refuse to give you a license if you got an outstanding citation that hasn't been fixed. For all of you who do property management or own rentals, one of the things you may do when you're screening tenants is look at their history, if they've had any problems with unlawful detainers and evictions in the past. And under current law, there's some real limitations. Well, there are some limitations on what gets published. Basically, if a tenant is caught up in the eviction process, but they prevail within 60 days after the unlawful detainer complaint is filed, that can't be looked at as a screening process, and it can't be published in terms of some of these companies that provide unlawful detainer reporting. The new law is going to flip that around entirely. They're going to make it so nothing gets published unless the landlord prevails within 60 days of filing. So for a lot of reasons, that doesn't always happen in the eviction process. There are a lot of things that can happen to slow down an eviction to the point where it's not complete within 60 days. So the practical effect of this new law, which goes into effect in January 1, is that there's going to be a whole lot of unlawful detainer actions that simply aren't getting reported. So it's going to be harder for property managers and property owners to find out if a tenant has a problem with previous evictions. Bed bugs and tenants. This is a new statute effective January 2018, and it's near and dear to my heart because I settled a big case this summer, and one of the issues was failure to disclose bed bugs. So a landlord is going to have to provide a written notice to tenants that includes all kinds of information about bed bugs, guaranteed to cause people's skin to crawl. It's going to talk about the appearance, the life cycle, and reproduction, what are bed bug bites, what are common signs of bed bug infestation. It's definitely a case of too much information. But starting in January of 2018, all tenants are entitled to that notice. The notice also has to describe the procedure for reporting bed bug problems to the landlord. Part of the new law is that whenever a pest control operator does an inspection of a unit for bed bugs, the results of that inspection have to be provided to the unit that's affected and also to the adjacent unit occupants. And a landlord's not going to be allowed to show a unit if they know there's a bed bug infestation that hasn't been cleared up. The law requires tenants to cooperate with inspection and treatment activities. But kind of curiously, it doesn't put any real affirmative burden on a landlord to do inspections for bed bugs. It says if you're aware of a possible infestation, then you've got to follow up. And then lastly, as in most situations in landlord-tenant law, a landlord can't retaliate against a tenant who reports bed bugs. So if you have any older projects that have bed bug problems, get them cleaned up before January next year. Then remember, any units you rent, you've got to provide these notices effective in January of 2018. Certified access specialist disclosures. This applies to commercial leases. It's Assembly Bill 2093, and it's effective immediately. So existing law requires a landlord to disclose on every lease or rental agreement whether a property has been determined by a certified access specialist to meet all applicable construction-related accessibility standards. And under the new law, any commercial lease is going to require a statement as to whether or not the property has been inspected. And then if it has been inspected, a copy of the inspection report, whether it's favorable or negative, has to be provided to the tenant within 7 days of signing a lease. And if the premises have not been issued a disability access certificate, then the lease has to include a lengthy statement about access specialist and the laws regarding access, all of those things. It goes on for quite a ways. And there's also, under the new law, there is a presumption that a landlord is responsible for any necessary repairs to make a unit accessible. So unless your lease clearly spells out it's the tenant's issue, it's going to be the landlord's problem. And then lastly, if there's a report that's not provided to the tenant at least 48 hours before signing the lease, the tenant has 72 hours to rescind the lease once they're given the report. So a whole bunch of things having to do with commercial leases if you're involved in that. Disclosure of death of an occupant. We've all known for several years the circumstances under which disclosure of a death has to be made. You know, basically, if somebody died on the property within 3 years before an offer is made, that has to be disclosed. And there's a change in the language of the law, however. Assembly Bill 73, which went into effect immediately, or just a couple of weeks ago, replaces some of the existing language, which was sort of wishy-washy. The existing law says no cause of action arises for failure to disclose a death on the property more than 3 years, or that an occupant was afflicted with or died from HIV. It doesn't tell you what your duty really is. It just kind of says there's not going to be any action that somebody can bring based on that. The new law replaces it with somewhat stronger language. It kind of protects you guys. It says it replaces the no cause of action arises language with language that just confirms that you don't have a duty to disclose a death that occurred more than 3 years ago, or an HIV afflicted occupant or death. And that's kind of important because there might be circumstances under which a crafty lawyer could come in, even though they can't bring an action directly on failure to disclose that, they might argue that as proof, for example, of a breach of fiduciary duty or something else. This law now is stronger. It confirms you simply don't have a duty to disclose that. But you have to be careful with these laws that say you don't have a duty to disclose something, because many of them, like this law, are safe harbors. Basically, you don't have an affirmative duty to go out and make that an issue, but if a buyer or a prospective tenant asks you directly a question, if they say, hey, do you know whether or not somebody who lived here was affected by HIV? Then you have to answer honestly. You can't tell a lie or weasel around it and rely on this law to protect you. That's kind of similar to Megan's law, which says if you give notice of the existence of the database, that discharges any duty you guys have as agents to figure out if there's a registered sex offender in the community. But if you're asked directly a question and you know, you've got to disclose it. So, residential environmental hazards booklet, there's been a slight change to the law there. It's been broadened. Existing law provides a delivery of the environmental hazards booklet is legally adequate to inform a buyer regarding common environmental hazards. The new law provides the same protection and extends it to leases of more than 1 year. So if you provided that booklet to somebody who's signing a lease for longer than a year, that's discharging your duty. Again, it's kind of in the nature of a safe harbor. If you have specific knowledge that goes beyond that, you need to disclose it. And the law is applicable to real property, which is kind of defined in a strange manner. It's defined to include almost everything except residential income property with 5 or more units. So, and as with existing law, delivery of the book is optional. Just if you want the protection of it, you need to provide it. PACE liens. Finally, we have a statute that requires some disclosures in connection with PACE liens. I bet probably half the people in this room have had a transaction that's either been lost because of a PACE lien or been affected by it. And as you know, the property assessed clean energy financing has been a thorn in everybody's side now since it's been out. And one of the problems that has been reported with PACE financing is that the people who are getting this financing aren't really informed of the potential problems with it. Generally, the existence of a PACE lien on property will prevent it from being refinanced in any manner. It will, unless it's paid off, it'll prevent the sale because somebody can't get new financing in most situations. FHA doesn't like these things, and there's a development on that we'll talk about in a minute. But the new law kind of imposes a disclosure requirement similar to TRID. It's kind of like the RESPA and combined disclosure that's required now on conventional loans. You've got to give a 3-day, involves a 3-day right of rescission after the docs are signed. You have to provide a notice that the seller may not be able to sell or refinance without paying off the PACE obligation. And what's really important, it expressly prohibits any shenanigans about representations by the contractor who's providing this financing with how much the value of the property is going to improve as a result of it. So I understand out in the field what's happening is there's been a really hard sell by home improvement contractors to use this financing, and one of the pitches they have is that your property is going to go up in value a whole lot more than just the amount that you're financing through the PACE lien. So if you want to make a representation about any kind of monetary or percentage increase in value, it's got to be backed up by a broker price opinion or an appraisal by a licensed appraiser or some kind of automated valuation model, whatever that may be. And then kind of related to that, FHA has had a stance since PACE liens first came on the scene of just not dealing with them. If you have a property that's got a PACE lien against it, you can't get FHA financing, and that was the end of the story. It's been anticipated for the last year and a half that FHA was going to relax its position slightly, and finally it has. It issued its mortgagee letter 2016-11, effective last month. It says now if a property is encumbered by a PACE lien, that doesn't automatically disqualify it for FHA financing. But again, you can't get too excited about this because the conditions that FHA has are going to be pretty difficult to meet right now. The PACE lien has to be treated like a special assessment. Only delinquent special assessment payments can take priority over a mortgage. Right now, PACE liens basically have super priority status, just like property taxes. And FHA will not loan on a property that has a PACE lien unless its subordination provisions are narrowly limited to overdue assessments. The PACE obligations have to be freely transferable upon sale. The ones I've seen so far haven't been, so that's going to require some changes. PACE obligations have to be recorded, and the outstanding PACE obligations have to run with the land. So there's going to be a whole bunch of bells and whistles that have to be on PACE liens to get FHA financing, but presumably if all these obligations are met, you're going to be able to get FHA financing even though there's a PACE lien on property. Then there's one other aspect of this new statute. A purchase contract, must state whether or not an existing PACE lien is going to be paid off or if it's going to continue on the property. And if it's going to stay on the property, you've got the purchase contract has to incorporate all the terms and conditions of the PACE obligation. The only effective way I can see for that to happen is to make the PACE loan docs, or the obligation documents, an addendum somehow to the contract. And I imagine standard forms will come out with something to accommodate that. And then an appraiser, the FHA appraiser, must analyze and report the impact of the PACE-related improvements on the value of the property. So a whole bunch of stuff on PACE liens. Contact information to HOAs. If you're an owner of a condo or a planned unit, you must annually provide to the homeowners association your contact information. And if you're not available, you need to provide the contact information of your legal representative, including somebody that has a power of attorney to act on your behalf. The HOA has to annually solicit that information from you, and if the occupant, the owner of the unit, doesn't provide it, the property address is deemed to be the mailing address for delivery of all notices. FHA condo regulations. I imagine a lot of you have had the experience of trying to get FHA financing on a condo and run into the fact that a condo is not currently eligible for FHA financing. I used to be called on periodically to write attorney opinion letters that the condo governing documents satisfied FHA requirements. I haven't had too many requests for that in recent years. But now, effective in federal legislation, has to be effective no later than October 27th, the requirements for getting condos certified for FHA finance are going to be relaxed a little bit. They're going to allow up to 50% non-owner occupied units in the project before a project can't get financing. Owner occupancy includes units occupied as a primary residence or a secondary residence. The new law is going to require FHA to streamline the entire recertification process, and it's expected that these changes are going to result in many thousands of additional units becoming available for FHA financing that weren't available for that financing now. There's a minimum wage increase scheduled to go into effect starting in January of this year. It ramps up every year. So those of you who have employees, it's $10.50 an hour in 2017. Keeps going up $1 an hour all the way up to, well, it starts at $11 in 2018. Finally, in 2022, it tops off at $15. There's an escalator provision where that gets adjusted for inflation not to exceed 3.5% a year. And for small businesses with 25 or fewer employees, which is presumably most of us here, that whole schedule is delayed 1 year. So instead of 2018, it goes to 2019 for the $11 an hour increase, that type of thing. And there's also a provision where if the economy is really in the dump, the governor can off-ramp the whole thing for a given year for any scheduled increase if he deems it necessary to help the economy or the budget. Getting close on time here, so I'll hurry up. There, a whole bunch of standard forms are due out, new ones and revised ones in December, so keep an eye on those. Just 5 I want to mention briefly. There's a buyer early occupancy addendum. That's kind of a really dumbed down version of an interim occupancy agreement. Be really careful with that. Standard forms, folks say that it was developed in response to a need that was expressed, that the existing form is too many pages long, too complicated. They wanted something simple. Just my advice to you is don't do those deals. Just do everything you possibly can to avoid early occupancy, because it's almost always a disaster. At least the ones that hit my desk are disasters. Maybe that's why they get to me. But you got people in there, they don't like the property, but then try to, they want to cancel the deal, or they try to get them out once they're in. That can really tie things up. There's also a seller license to remain in possession addendum that's going to be available for basically the flip of that, where the seller needs to stay in possession a little bit longer. That's not as much of a problem in my experience, but still it can be a problem, especially if the seller doesn't leave on time. Your legal remedies are somewhat limited, and it's a difficult situation to be in. There's a new agent commission sharing agreement, which is a really nice tool if you're involved with a team and you want to have a better formalization of your arrangement. And then there's a couple of new ones that are kind of interesting. There's a summary sheet for multiple offers and a summary of the RPA offer. And both of those are really useful tools kind of for comparison of terms, especially if you have multiple offers. You can look at price, financing, escrow period, all those things are all set out in a kind of a side-by-side format like you would do if you were analyzing an investment. And the only caution I would have for you guys using that is make sure you're putting the information down accurately, because I can see problems coming if several offers say different things than what is represented in the multiple offer summary sheet. A couple of things on cases just to wrap up here. there is an unreported decision, and usually what happens in California for a case to be citable as precedent, it has to have gone through the trial system, gone up to the Court of Appeal, has to have been an appellate decision, and then the Court of Appeal has to certify it for publication. That means it's significantly important that you can rely on it as an interpretation of California law. There's a case that came out in April that was not certified for publication, so we can't use it as binding precedent, but the facts are interesting. What happened is the buyer comes in, it was a dual agent transaction, and the buyer asks the dual agent, what's that musky smell? And the agent says, it's just sea air. You can fix all that, just repaint, change some of the sheetrock, you'll be fine. Well, it wasn't. The buyer purchased the home, closed escrow, investigated, and found a buried septic tank and a buried oil tank. And what you need to keep in mind here is the broker and the agent paid $275,000 to settle the case. And that wasn't part of the reported case. The case went to trial against the seller, and all kinds of crazy things happened in the trial court. So it went up on appeal and got reversed in part, and crazy stuff happened. But just keep in mind, when you're making any disclosure, just talk about the facts. Don't editorialize or speculate, and don't say things you don't know to be true. And then lastly, as I mentioned at the beginning, the Horiki case. Horiki versus Coldwell Banker involves the question of whether or not in a dual agent transaction where you have in a single office that's a dual agent, you have one agent working with the seller and they have the listing, and one agent working exclusively with the buyer. In that situation, does the agent working exclusively with the seller who has the listing, does that agent owe a fiduciary duty to the buyer? And what happened in Horiki was kind of an interesting, you've heard enough about this already probably, but it's coming up, the decision will be out within the next few weeks, everybody anticipates, so it's worth reviewing again. What happened in Horiki, the property had been listed originally, and the listing agent found a buyer. And in the course of that transaction, they gave certain advice and made certain disclosures to the prospective buyer. That escrow fell apart and didn't close, so it goes back on the market. This time another agent in the office brings in the buyer. The listing agent doesn't give the same advice or make the same disclosures to the buyer in that transaction. And the buyer finds out about that after escrow closes and files suit, saying, hey, you breached your fiduciary duties to me. And during the course of discovery, it was determined that, yeah, in a prior transaction, the listing agent had done more to protect the buyer. So then the question is, well, gee, did that listing agent really owe a fiduciary duty to provide that information to the buyer? Trial court said no. There's no duty of a listing agent in a dual agent transaction no fiduciary duty owed to the buyer. Went up to the Second District Court of Appeal in Los Angeles, and they said no, trial court got it wrong. In a dual agent transaction, every agent in the office who's involved in the transaction owes a fiduciary duty to both parties. That's the basic nature of dual agency. Obviously, that caused quite a stir, and California Association of Realtors got behind it and threw some money at it, and it went up. There was a petition made to the Supreme Court, which was accepted, and now it's up on review. It's been fully briefed. Just a huge number of briefs have been filed by different interested parties, and it was argued last month, and a decision could come out any time. My personal thought on it, it's not good for the industry that you would have that extension of fiduciary duty confirmed, but I think logically it kind of makes sense that if you've got an office that's a dual agent, everybody in the office should owe fiduciary duties to everybody. But that's going to make, if the Supreme Court comes down and says that, it's going to make dual agency transactions even more dangerous legally. Most of the really difficult cases I have to defend usually are dual agent transactions. So keep that in mind if you have a situation. If you do take on, if you are involved in a dual agency deal, be really, really careful with your conduct throughout the whole thing. And that's it. Anybody have any questions?